A unanimous suppressor decision just dropped, and the Department of Justice did the unthinkable. They reversed their entire position and admitted NFA suppressor regulations are unconstitutional. This changes everything for 2.6 million suppressor owners. Hit subscribe right now because what I'm about to show you will blow your mind. The confession that changed everything. The federal government just filed a 47-page admission that they've violated your constitutional rights for nearly a century. After spending $400,000 defending suppressor regulations, the same DOJ attorneys are now tearing apart every argument they previously made. Music. This reversal happened across 6 federal circuit courts simultaneously, making it impossible for the government to claim it was an isolated mistake. The 156-page defense brief from September 2025 is now being cited by gun rights attorneys as evidence of government bad faith. The federal government just admitted they've been wrong for 90 years. On January 20, 2026, the Department of Justice filed a 47-page document confessing that suppressor regulations violate the Second Amendment. This wasn't a procedural technicality or a minor policy adjustment. This was a complete institutional surrender in United States versus Patterson. Here's what makes this unprecedented. Music. The same legal team that defended these regulations spent $400,000 of taxpayer money writing a 156-page brief Music just 4 months earlier. Now, they're systematically dismantling every argument they made. They conceded suppressors are in common use with Music, 2.6 million registered units, admitted the $200 tax creates financial barriers, and acknowledged no historical precedent exists. Music from America's founding era. The reversal expanded beyond one case. DOJ attorneys filed position changes across 6 different federal circuit courts simultaneously from Arizona to Maine. Cases that consumed 3 years of litigation suddenly collapsed as government lawyers withdrew opposition. The financial impact alone is staggering. Legal fees totaling millions of dollars evaporated overnight as the government raised the white flag. But here's the calculated part most people missed. The DOJ specifically limited this confession to suppressors only. They explicitly stated this should not apply to machine guns, short-barreled rifles, or other NFA items. Music. The government was trying to sacrifice one category to save the rest: music. The court, however, had different plans that nobody saw coming. The instructor who accidentally broke the system. A shooting instructor trying to save his hearing just accidentally dismantled 90 years of federal gun control. Patterson waited 11 months for suppressor approval while buying 3 other firearms in under 45 minutes, all with the same background check. His permanent 40% hearing loss became the medical evidence that exposed the absurdity of treating hearing protection as a regulated weapon. The $650 suppressor he bought would have reduced gunfire from 165 dB to 132 dB. Still loud enough to require ear protection, but below the permanent damage threshold. Michael Patterson never intended to become a constitutional warrior. He's a firearms instructor in Scottsdale, Arizona, running a training academy that teaches defensive shooting to law enforcement officers and civilians. Music. After 15 years of instruction, he developed permanent hearing damage, 40% loss in his right ear, and constant tinnitus that prevents him from sleeping without white noise machines. His iologist delivered a stark warning. Continue teaching without better protection and face complete deafness by age 50. Electronic earmuffs weren't enough because instructors need to hear student questions and range commands. In March 2024, Patterson purchased a Silencer Cumber Omega 9K suppressor for $650. Music not as a political statement, but as medical equipment to save his remaining hearing capacity. The bureaucratic maze he entered was absurd. Patterson submitted 2 sets of fingerprints, passport photos, notified his county sheriff, filled out an 8-page ATF Form 4, and paid $200 for permission to protect his ears. Music during the 11 months and 17 days his application sat waiting for approval. He purchased 3 regular firearms that were approved in under 45 minutes combined, all requiring the identical FBI background check. The Firearms Policy Coalition approached him about challenging the entire constitutional framework. Patterson agreed on one condition. The case must seek relief for every suppressor owner in America, not just music him. He filed suit in September 2024, and District Judge Sarah Henderson issued a 73-page ruling in his favor. Then the DOJ appealed to the one place where Second Amendment claims go to die. The irony wasn't lost on anyone. The government made Patterson wait nearly a year to protect his hearing while approving purchases of actual firearms in minutes, proving the system was never about safety. The court music where gun rights go to die. This 3-judge panel had ruled against gun rights 67 consecutive times until now. The Second Amendment Foundation allocated $280,000 just for the appeal, expecting complete defeat and preparing for a Supreme Court battle. Gun rights organizations were so certain of losing that they drafted 3 separate Supreme Court petitions before the Ninth Circuit even issued its decision. The panel's combined judicial record showed they had upheld every single California gun restriction that came before them since 2012. The Ninth Circuit Court of Appeals had ruled against gun rights in 23 consecutive cases since June 2022. Music. That's not an exaggeration. 23 straight losses. They upheld California's assault weapon ban, magazine capacity limits, ammunition background checks, and even restrictions on firearm advertising visible from public streets. This circuit court covers 9 western states and 65 million Americans. The 3-judge panel assignment was devastating. Judge Paul Watford previously upheld California's 10-day waiting period, even for people who already own firearms. Judge Andrew Hurwitz authored Hawaii's open carry ban decision. Judge Jacqueline Nguyen had never music voted to strike down a single gun regulation in her entire judicial career. Music. Yeah. Their combined record 0 wins for gun rights across 67 cases. Gun rights organizations prepared for catastrophic defeat. The Second Amendment Foundation allocated $280,000 expecting to lose and need Supreme Court resources. The Firearms Policy Coalition war gamed scenarios, music, where the Ninth Circuit would issue an opinion so hostile it would make things worse by creating binding bad precedent across the entire western United States. Music oral arguments were scheduled for January 28, 2026. Then something extraordinary happened 8 days before that hearing. Music. The government's confession of error meant oral arguments never occurred. Instead of the expected disaster, Patterson won a unanimous decision from the most music anti-gun panel in America. But what you don't know is why the government surrendered and the legal framework that made their position completely indefensible. What do you think forced the DOJ to surrender before oral arguments? Internal legal analysis, political pressure, or fear of an even worse Supreme Court ruling? The Supreme Court test that destroyed 90 years of law. The 2022 Bruen decision created a constitutional test that the government spent $225,000 trying to pass and failed completely. DOJ researchers searched for 7 months through founding-era laws and found absolutely nothing that could justify taxing suppressors. The 2022 Supreme Court decision in New York State Rifle and Pistol Association versus Bruen eliminated the way courts had analyzed gun laws for decades before music Bruen. Jing courts used a balancing test, weighing government interests against individual rights. Under that framework, the government won almost every case because judges could simply declare public safety more music important than constitutional rights. Justice Clarence Thomas wrote that, music, the Second Amendment is not a second-ass right subject to interest balancing. The new standard requires 2 steps. First, does music, the constitutional text, cover this conduct? Second, if yes, the government must prove the regulation matches America's historical tradition from the founding era. No balancing, no exceptions for public safety, This created an impossible problem for suppressor regulations. Music. Hiram Percy Maxim didn't invent suppressors until 1902, receiving his patent in 1909. They literally didn't exist in 1791 when the Second Amendment was ratified. There cannot be founding-era regulations of technology that music didn't exist yet. The government needed historical analogies, similar regulations from America's early history that burdened rights in comparable ways for comparable reasons. The DOJ commissioned music, two separate historical studies costing $225,000 combined. Georgetown Law Center researchers and independent historians searched for 7 months. They found colonial-era gunpowder storage laws, dangerous instrumentality regulations, and British poacher restrictions. Every single analog failed. Storage laws don't compare to ownership taxes. Explosive regulations don't apply to safety devices. British game laws were explicitly rejected by American founders. The government found nothing that survived scrutiny. And here's what happened when they had to admit it in court. 3 pillars that demolished federal gun control. An 89-page unanimous opinion just established 3 independent legal reasons why the NFA suppressor regulations are unconstitutional. Each pillar stands alone as sufficient grounds to strike down the law, meaning the government must overcome all 3 to reverse this decision. Chief Judge Jacqueline Enuan's 89-page unanimous opinion rests on 3 independent legal pillars, each one sufficient by itself to destroy the suppressor provisions. The opinion is binding precedent across 9 Western states covering 65 million Americans. Music legal scholars are calling it the most important Second Amendment decision since 2008's Heller Music ruling. And Pillar 1 addresses common use. The government argued 2.6 million suppressors represent only 2% of gun owners, making them unusual. Judge Ningguan demolished this by noting that's more than the entire active-duty U.S. military, more than Ford F-150 trucks sold in 2024, and shows 622% growth since 2012. The opinion states governments cannot claim items are unusual when their own regulations prevent those items from becoming common, like requiring $10,000 licenses for cars, then claiming cars are rare. Pillar 2 addresses the $200 tax as prior restraint. In 1934, when the NFA passed, $200 equaled 2 months of average salary. Today, it's a 30% tax on a $650 device. The court compared this to poll taxes that were struck down, protest permit fees that were eliminated, and reading tests for voting that were abolished. Constitutional rights cannot require payment to exercise. Music. For Americans earning $28,000 annually, $200 represents 2.5 days of pre-tax income. Music. Pillar 3 addresses administrative delays as effective prohibition. Patterson waited 11 months and 17 days while the ATF had no statutory deadline to approve his application. Music. Some applicants wait over 18 months with no recourse if the government simply never processes paperwork. The court ruled that a registration system with no time limits and no enforcement mechanism constitutes a de acto ban. But the court didn't stop at striking down the law. They issued an implementation order that changes everything starting now. What actually changes starting now? The court issued a 90-day implementation timeline that ends $200 tax stamps, eliminates year-long waits, and triggers $69.44 million in refunds. Starting January 23, 2026, buying a suppressor takes the same amount of time as buying any other firearm. Typically, music, just minutes. Judge Nguyen's opinion includes a detailed 90-day implementation timeline, preventing the chaos governments always warn about when gun laws fall. This is unprecedented. Courts typically strike laws down and leave enforcement gaps. Here, the court anticipated every objection and solved it. The maintaining background checks while eliminating unconstitutional requirements. Effective January 23, 2026, the ATF must stop collecting $200 tax stamps, music, for new purchases. Walk into any gun store, select a suppressor, fill out the standard form, 4473 background check form used for all firearms, Music, wait for instant NICS approval, typically minutes, and leave with your suppressor the same day. No fingerprints, no photographs, no ATF Form 4, no Chief Law Enforcement Officer notification, no trust paperwork, no 11-month wait for 347,000 people currently waiting on pending applications. The ATF has 14 days to auto-approve every application by February 6, 2026. And anyone who passed the background check gets automatic approval within 90 days by April 23rd. The ATF must refund all $200 payments for applications submitted after January 1, 2024. That's approximately $69.4 million in refunds processed music through the IRS. Most significantly, anyone currently in lawful possession of any firearm, music, is now deemed a lawful suppressor possessor without registration. The NFA registry for suppressors becomes obsolete. Existing registered suppressors can transfer like any firearm. Background check required, music, but no ATF approval wait. The used suppressor market will explode since transfers no longer require Form 4 processing. But here's what nobody's discussing about the 8 states where this creates a massive legal conflict. Do you think the ATF will comply with this timeline by April 23rd? Or will they fight this decision and create chaos? The state law trap nobody's talking about. 8 states still have suppressor bans that can send you to prison for 3 years, even though federal law no longer prohibits them. California Penal Code Section 33-3410, music, makes suppressor possession a felony with mandatory prison time, music, completely independent of federal NFA regulations. This is a federal court decision striking down federal law. 8 states have independent suppressor bans written into state criminal music codes: California, New York, New Jersey, Illinois, Massachusetts, Rhode Island, Delaware, and Hawaii. If you live in these states, you're still committing a state felony by possessing a suppressor even though federal law no longer prohibits it. Music, California Penal Code Section 33410, makes suppressor possession a felony with up to 3 years in state prison. New York Penal Music Law 26510 classifies them as dangerous weapons with mandatory minimum sentences. These weren't written as enforcement mechanisms for federal NFA law. They're independent criminal statutes that remain fully enforceable. State police could arrest you even while federal ATF agents cannot. However, the 14th Amendment incorporates the Second Amendment against state governments, meaning states face identical constitutional limitations as the federal government. If federal NFA suppressor provisions violate the Constitution, then identical state provisions also violate it. The legal pathway is clear, and attorneys are already executing it. California has a pending suppressor ban challenge that was stayed awaiting federal NFA developments. That stay will lift immediately, and attorneys estimate at least 5 of the 8 states will lose their bans within 12 months. New York and New Jersey will fight harder, potentially taking 18 to 24 months. But the legal reasoning from Patterson applies directly. Music states cannot do what the federal government constitutionally cannot do. What's coming next, though, will shake the entire firearms regulatory framework to its foundation, the domino nobody expected. The court's 20-page guidance section just gave attorneys a roadmap to eliminate short-barreled rifle restrictions, and 3 lawsuits were filed within 18 hours. Judge Muyan wrote she could find no principled distinction between an AR-15 pistol and rifle with identical barrel lengths except the $200 tax. The opinion's legal reasoning doesn't stop at suppressors, and Judge Naguya knew it. She included a 20-page section of dicta statements not legally necessary to decide this case, but providing guidance for future litigation that systematically applies the same constitutional analysis to short-barreled rifles and shotguns. The implications are devastating for what remains of the National Firearms Act. Music short-barreled rifles defined as rifles with barrels under 16 in. You have been NFA items since 1934. The government's justification has always been that SBRS are concealable, but the opinion points out that millions of Americans legally carry concealed handguns in all 50 states after Bruin struck down May issue permitting schemes. Approximately 4.2 million AR-15 pistols with barrels under 16 in are already in civilian hands. Judge Nguyen wrote she could find no principal distinction between an AR-15 pistol with a 13-in barrel and an AR-15 rifle with a 13-in barrel, except one requires $200 and one doesn't. 3 separate lawsuits challenging SB provisions were filed within 18 hours of the Patterson decision, all strategically filed in the Ninth Circuit to take advantage of binding precedent. Legal experts give these cases 95% success probability. The government already admitted they cannot defend arbitrary barrel length restrictions under Bruin's historical standard. There's no founding-era precedent for 16-in barrel requirements. That number was chosen arbitrarily in 1934 based on what committee members thought sounded reasonable. But the ultimate question everyone's asking is whether this legal framework will reach the one category that terrifies gun control advocates most. The ultimate constitutional showdown coming. Music. The legal framework that destroyed suppressor regulations is now being applied to the 1986 machine gun ban, and it could eliminate the Hughes Amendment entirely. Music. Before the 1986 freeze, machine gun registrations grew at 15,000 to 20,000 annually. Continuing that growth would mean 1.2 million registered machine guns today. The 1986 Hughes Amendment prohibits civilian possession of machine guns manufactured after May 19, 1986. This created a closed registry of approximately 630,000 transferable machine guns, artificially driving prices from $600 manufacturing cost to $15,000 to $40,000 market value. The constitutional analysis for machine guns is more complex than suppressors. First, the opinion explicitly states governments cannot argue something is unusual when their own regulations prevent it from becoming common. Before 1986, machine gun registrations grew at 15,000 to 20,000 annually. If that growth had continued, over 1.2 million registered machine guns would exist today, easily meeting common use thresholds. Second, Patterson holds that registration and taxation requirements are unconstitutional prior restraints. The Hughes Amendment doesn't merely tax or register machine guns, it bans them entirely for civilians. If a $200 tax and registration violate the Second Amendment, music and absolute prohibition certainly does. The 1939 Supreme Court case, United States v. Miller, stated, "The Second Amendment protects weapons with reasonable relationship to militia use, and machine guns are standard military issue globally." The Firearms Policy Coalition confirmed they're preparing a Hughes Amendment challenge for filing in the Fifth Circuit, the most gun-friendly federal appellate court. They're recruiting plaintiffs who are FFL manufacturers currently possessing post-1986 machine guns as dealer samples. The timeline is 2 to 3 years to reach the Supreme Court. Music, but Patterson established the constitutional framework that makes this challenge viable for the first time since 1986. Do you think the Hughes Amendment machine gun ban will survive constitutional scrutiny after Patterson? Music. Or is the entire National Firearms Act finished? The National Firearms Act is crumbling in real time, and most gun owners have no idea this is happening. Music. If you want to stay ahead of every major development in firearms law, hit that subscribe button and turn on notifications right now. Like this video. Share it with every gun owner you know.